these issues with unique connection and confidence. Counselor, welcome to Primetime.
Thank you, Chris, for having me. I appreciate it. Look forward to being with you.
All right, so let's make the most of this opportunity.
Sure.
Kavanaugh.
Yep.
This is a weird one, right? We struggle with this. There is no trial. So,
Right.
how do you deal with the burdens? How do you deal with the presumptions? How do you deal with process in an overtly political context, which this is, right?
Yeah.
The call right now is by the Democrats and by Professor Ford, let the FBI take a look, and then I will come in and answer whatever you want. Fair as.
So here's how it works. I mean, this is the way the Constitution's. I think Dr. Ford should get a fair hearing. I completely agree with that. The idea that she should have a fair opportunity to present her case. The way it works, though, as you said, Chris, this is not a trial. So this is a proceeding before the Senate. So let's look at what the Constitution says. The Constitution says the president has the right to nominate judges and justices. It actually doesn't even use the phrase justices.
That's
It says
right.
judges to the Supreme Court of the United States. Okay, so he did that with Brett Kavanaugh. Then the Senate, under their authority, has the advice and consent role. That's not just a rubber stamp. That is a process. That process is underway. Now there's been an allegation. So I think the safest thing to do here is to follow the Constitution. Now, I'm not going to get into whether 2 days or 3 days or it should be Monday or whatever. That's the Senate's role here. I think that Dr. Ford should be given an opportunity to appear and to make the case. I think that Judge Kavanaugh should be able to respond to that. I think that's appropriate. By the way, doesn't mean it has to be done publicly. They could decide that if Dr. Ford, I understand the transparency issue, but if Dr. Ford wanted to do it privately, I think she'd have the right to do that.
Well, they've offered her that. There's no
Yes,
question.
they have.
And look, I get the sensitivities. I mean, she has the threats.
Sure.
She's got kids. Her family is not living at home right now. I totally get that. But,
Sure.
for the full complement of senators to make an assessment, for the rest of us to have any confidence in what happens there, especially given the poison politics of this confirmation process, I think it's going to have to be open. But
you said something really important there, Chris, and that is that for the Senate to have its role, and I think what's getting overlooked, and you haven't done this, but others have, and that's overlooking the Senate's role here. This is a situation where the United States Senate is vested with the advice and consent right. And that means that they can have the hearing, they can vote yes or vote no, they determine veracity, and they determine process. That is the appropriate venue constitutionally.
But there's a this and that issue here that I think you're neglecting with all due respect, Counselor, which is the FBI is not a stranger to this process. They do the background assessments every time with judicial nominees, and you have precedent here. With Anita Hill, when that came forward as an allegation, President Bush said to the FBI, take a look. They took a few days, they took a look, they said, we can't corroborate this. It then leaked, and you wound up having public hearings. The same mechanism could be in place here. The president could go back to the FBI, who already did a background review, which they always do. The Congress cannot go back to the FBI and say, reopen the background. That's at the White House's direction. But he can, and do exactly what President Bush did. Why not?
Well, I'm not going to speak. I'm not the president's White House counsel, so that's not my job to interject.
Hello.
No, Chris. No, look, I'm being fair here.
All right.
I don't get to determine the policy and process that the White House engages in. That's not my job. My job is to look at, and the reason we're talking about this tonight is, look, a serious allegation has been raised. It needs to be handled appropriately. I go to the Constitution and say, let's look at the way the process should work out. I don't think anybody actually disagrees with that.
Well, but the
question
FBI
that you're asking is, what should the FBI do or not do? Now, let's look at that process too. Number one, and I think you've acknowledged this the other night, the FBI is not, in this particular case, looking at a criminal action investigation. So for those that are watching the broadcast, I think it's important to point out, what would the FBI do? If the FBI were to do an investigation or a follow-up, it's basically a follow-up to their report that they give to Congress, that they would give to the White House if it was asked for. And that's the way the process would go out. So again, I'm not one that gets to make the policy decision on that.
But what's wrong with that?
Well, it's not a question of what's wrong with it. It's who makes that decision. It's not
the president would have to make the
decision. Not the president's private lawyers.
I understand. I totally get it.
Yeah.
But what I'm saying is this. I'm just asking you this as a legal mind right now. We'll get more and more specific to your current state of employment with the lawyer and on these separate issues. But on this one, the president can make the call, right? Absolutely. Presidents have made the call in the past. And at a minimum, it would ensure a little bit of more confidence in an overtly untrustworthy process, because everybody's got a political agenda. Why wouldn't he want to give his own nominee the best look he can? Because Kavanaugh's got to want to have people look into this also.
Look, I don't know what the president's thinking is on that. I don't know what the White House counsel's thinking is on that. Again, that's not my responsibility. But what I do think is important here There's been a serious allegation made. There needs to be due process. It's not in the, again, not in the court system that we're talking about here, within the Senate. And the Senate can, look, they're putting these people under oath. I mean, Brett Kavanaugh, Judge Kavanaugh, and Dr. Ford, they go under oath. So it's under the penalty of perjury for all the parties that are witnesses. And I think that then in that case, that's the way to do this. I think it needs to be fair. Again, whether it should be Monday or Wednesday or whatever the period of time is, look, the Supreme Court starts its term, was it first Monday in October? I think this year's October 1st. Will Brett Kavanaugh be confirmed by then or not? I don't know. Again, because that's not my job here. My job, I'm looking at this as an observer. I am not giving advice on this. Obviously, it's not my role. But I think, look, this, again, needs to be done appropriately. It needs to be done properly, and it needs to get a fair hearing. For both individuals involved in this. And I don't discount the seriousness of this. I think anybody that is making a mistake. But I also don't think that Judge Kavanaugh should be just left out there. I think there needs to be a full and fair process. And how that process looks again, Chris, that's not just my decision.
100%.
I mean, that's not my decision actually at all.
100%.
And that's the Senate. You know, the Senate has a big role here, as you know.
Yeah.
And they're gonna.
They just can't call in the FBI. The president does. That's why I was asking you about it.
Yeah,
Let's
I mean,
take one step closer to your official role with Sessions.
Yeah.
Hasn't anybody explained to the president that Sessions had no choice but to recuse himself? You know all the DOJ guidelines, but just for the audience, if we have it, put it up, of what the rule is here, that if you have a connection to anybody who's going to be a subject of or in any way affected by an investigation, you must recuse. Where's the surprise for the president?
Well, look, the recusal took place before the president, first of all, I've said this before, and you know this, and the reports have been out there. The recusal took place before this was an inquiry like this. I mean, let's look at this. So I will tell you that I understand the president's frustration in this situation. And I think if you were in the situation, you would too. Having said that, look, there was a process that was followed. Do I think, and I think you could get lawyers that could agree and disagree. I will tell you this, and I know my colleague Rudy Giuliani has opined on this as well. But I think, look, the recusal, everybody needs to remember this. When did the recusal take place? Before what? Before the appointment of all of this. Before the appointment of the special counsel, there was recused. Well, I mean, so that tells you that the frustration point, it wasn't where you just gave the regulation. That regulation really has,
just so people can see
sure, yeah, the regulation has nothing to do with, in this sense, of what actually transpired. Sure, there's internal regulations, but the recusal issue is one that, look, General Sessions made that decision. I don't think it was the right decision. There are people that could disagree. I get that. People can disagree. Reasonable minds can take different positions here. But let's be clear. It was before there was any special counsel appointment. So, that to me, I think it was, again, I understand.
There was an ongoing investigation. It was going to involve all of the different checks, that they have to think about with that guideline. And then the president says, if I had known, I would have picked somebody else. Okay, fair point. You had a chance.
Well, really a fair point. I mean,
but I'm saying fair point. I get it.
Significant point. Yeah.
I get it. So you would have wanted somebody else. Okay, you had a chance. You had Rosenstein. The president picked Rosenstein after the recusal, and as we know, the president and Sessions both massaged a situation with Rosenstein where he wrote that very favorable memo.
I think that's an unfair character.
So that was his guy.
But hey, first of all, Chris, you're making an assumption. You just said, if I heard you correctly, you said that Rosenstein, Rod Rosenstein, massaged the memo.
I'm saying that
so
the president and Sessions massaged the situation.
Why do you what's your basis for that?
Because they brought him
what
in.
evidence do you have of that?
Timing. He was brought in. Yeah, well, it counts.
Okay.
Hear me out and then object as you like.
Yeah.
He comes in. He is then asked to write a letter about Comey and assess.
How do you know this?
Well, how did it happen?
Well, how do you know this?
What, did he just do it on a whim?
Well, let me ask you this
It
question.
was reported as such. Yes.
You and I have been friends. Do you understand? Do you have the facts on that to support that? I'm not gonna. Well, okay, it's been reported.
Yeah.
But has Rod Rosenstein testified to that? That he was massaged? No. I mean, let's go back.
No. You're talking about the massage. Why did he write the letter, Jim?
Well, why did he write the letter? But I assume he wrote the letter because he thought that James Comey should not be the FBI.
Who told him to make the assessment?
Well, do you think it? Who do you know who told him?
I think somebody had to tell him, because he wouldn't have just done it on his own. He came in to be the deputy acting, and the first thing he decides to do is just write a letter about how Jim Comey's got to go with the FBI.
Well,
nobody asked him to do it.
Here's the problem. You're making a factual assumption that you have no basis to state.
That's not true. I do
has Rod Rosenstein testified that he did this just because the president ordered him to, which is what you just said, basically? He did not. He has not testified to that.
Wait, let's parse it. Have I heard Rosenstein say I only did this because the president told me to? No.
Okay.
Do I believe that Rosenstein did this at the direction or suggestion of other people? Absolutely. Why?
Well, Chris, look,
Nothing else makes sense.
Well, how do you know that?
Why else would he have
Let me
written
give
the
you, for
letter?
instance, because in an election, James Comey, and if you want to play the clips of Chuck Schumer and
Right.
others, who said James Comey
Hated him.
when he, well, look what he, why? In the
Because they
middle of an
felt that he
election,
tilted the election in favor or away from their candidate.
he engaged, he violated the Department
Yes.
of Justice guidelines, which
Yes,
is
that's what they
don't
say.
well, that's what happened. And
Well,
he
that's what they
engaged.
say.
Okay, so he was fired. And looking at it, Rod Rosenstein makes an assessment.
Why did he look at it?
Well, because he was just
He
sworn
made
in.
the assessment before he was fired. So why did he do it?
Well, you tell me. You think
No,
it's because
you
the
tell me,
president
because
ordered it.
you
And Rod, I'm
reject.
telling you,
You
Rod-
reject my
No.
explanation.
I'm not rejecting your explanation. What I'm saying is Rod Rosenstein made a determination
Yes.
and made a recommendation to the president.
Yes.
And that was also signed by the way, by the Attorney General.
Yes.
So, and the president acted on that. And that's completely,
Maybe,
I don't
maybe
think-
not,
well,
because
hold
the
it.
president doesn't
I don't
say that.
think, do you think that, first of all, constitutionally under Article 2, you know this, Rich, you're a good lawyer.
He can hire and fire.
Absolutely. James Comey said that.
Not for bad
So-
reason, though.
So, well, hold it. He can, the Constitution is very clear on this.
No, it's actually absent on it. It says hire or fire. It doesn't say for
No,
any
the
reason
Constitution actually
whatsoever,
doesn't say
not
hire
even
and
if it's
fire.
illegal
Okay,
and nefarious.
Chris, the Constitution doesn't say hire and fire. That's not in the Constitution. It's the Article 2 authority of a president to hire and fire. Not because the Constitution doesn't have the word hire and fire. That's
Right.
the impact of the plenary authority of the President of the United States.
Understood.
So,
So
again-
there's got to be a check on that. It has to be reasonable that the firing can't be for bad or corrupt reason.
What if the president thought James Comey was doing a bad job?
Then he can fire him.
Okay, so you're now saying that a third party could come in, under your theory, and come in and say, we want to examine the President of the United States' intent as to why he took an action under his Article 2 authority.
Yes.
Now, what prevents every U.S. attorney that doesn't like a decision put this president aside, that any president makes, what prevents that U.S. attorney from saying, I want to subpoena the president and find out why he fired the
You gotta have a good basis.
undersecretary
You
of
gotta pass.
whatever?
You have to pass legal muster.
Well, what does
and
that
show
mean?
that-
What does legal
You
muster
have
mean
to
under your
show
theory?
that you have legal sufficiency. In this case, if they're
Who
pursuing
are
an
you showing,
obstruction.
by the way, who are you showing that legal sufficiency to? It's not a court proceeding. So who are you showing the legal sufficiency to? So here's the
Well,
problem.
you have
When
the same guy that you put in, that the president asked to guide him and give him suggestions about Comey,
Well,
who
can I
is
ask you a question about that?
Rosenstein.
Let's assume that was the fact for a moment.
No,
there
it
anything
is the
wrong?
fact.
let's
Rosenstein
assume it is.
said it.
Okay, so let's say it. So is there anything wrong with the president asking the deputy attorney general for a recommendation on James Comey's employment as the FBI director?
I would say no.
You would say
However,
of
one
course not.
step backwards.
Right.
One, you were questioning whether that ever happened.
No. I'm saying
You were saying I don't know that the president
Chris,
never
I'm not
massaged
gonna-
this situation.
You
Yes,
don't know
I
that.
do. He
No, you don't.
asked Rosenstein for a
his opinion?
suggestion about what to do on
Well,
Comey.
is that a violation of his article? Do you think
I'm
that's
saying
a
it's a
violation
matter
of the
of
law?
fact.
No, Chris.
I'm
Chris,
saying it's a
let's
matter
assume
of fact.
it's fine. Does that violate a law?
I'm not
If the
saying it
president
does. You
says
said,
to me-
how do you know the
Well, I don't
president
know how
has
you
to
know
do it?
other than
Rosenstein said it.
No, Rosenstein said he did not say he did it on the president's behalf.
He said the president asked him
For his opinion.
counsel and suggestion.
Well,
So he
that's
wrote
what-
the letter.
So let me ask you a question. Is that not appropriate for a president to ask?
One step at a time. I'm saying
Well, no.
that's
Is
why
it
he did it. You
appropriate
said, how
for
do you know? Now I'm
No,
telling you
okay.
how I know.
So
then
I'm
he
saying,
did it.
so is it appropriate for a president
Yes.
to ask the deputy attorney? Very
100%.
different than massaging.
Yes.
Because
Then
you're trying to give
Chris-
it like nefarious.
Oh, I know. Look, that's my suggestion. That's my
Got it.
characterization based on what I understand.
And I'm telling you, if the president of the United States, any president of the United States, asks their attorney general or deputy attorney general for advice, which by the way is what their job is,
Right.
then if he acts on that advice, he should be investigated for acting on their advice.
But there's a but here. Because then what happens? Yes, it all works perfectly. Rosenstein gave him this letter, was damning of Comey, free clear. Go ahead, get rid of him. You have
You think
plenty of reason.
you think Rod Rosenstein's lying?
No, it's not about lying.
Okay.
So listen. So he writes that letter. This is his opinion. He can't be lying about his opinion, right? Unless he gave it in bad faith, and I have no reason to believe that.
Right.
So the president does the interview with Lester Holt and says, I was going to fire him anyway. Because I said, this Russia thing, it's just not right. I'm getting rid of him.
That's
So
actually
he blows the Rosenstein
Yeah.
letter out of the water and makes
Actually,
it clear.
not interviews, there are edits, and there's a longer transcript. And I will just tell you, without disclosing any detail, that when you review the entire transcript, it is very clear as to what happened. And I'm not going to give you information on how we provided it, but in our professional discussions with the Office of Special Counsel, we've addressed that on multiple occasions appropriately. And the evidence, when you look at the entire evidence, and you don't see it, and I'm not, by the way, I'm not faulting anybody for running a clip or this, but to turn that into literally a federal case, we don't think is right, we don't think it's constitutional, and we think the entire transcript, without question, supports that the president realized that when he fired James Comey, it might actually extend this investigation, and he said that on the tape.
Look, not that it's the most compelling evidence, but then you have a scene afterwards with the Russians in the Oval Office where the president says to them, now a lot of pressure's off me now that I got rid of Comey with this whole Russia deal. Well, look, if it wasn't on his mind, if it wasn't a motivation for him, legal or illegal, right or wrong, it was clearly in his mind about why he wanted to get rid of Comey.
But again, you're acting as if that's not a constitutional right, if that was, in fact, what was in his mind. And again, that's speculation. But I think that that's what we have to be clear here. So I have to look at what the law is, as the evidence exists, and what the law is. And when you get to the Article 2 issue, it's a very serious moment, constitutionally, for our country, if a president decision-making on what's called inferior officers, that's not in a pejorative way, it's just the way the Constitution, that's actually what the Constitution and the rules and regulations actually say. And to say that you could then cross-examine, so to speak, the president, any president, on that decision, very dangerous, and that's exactly the reason we have
you wouldn't
separation of
suggest that you should never do it, would you?
Where you never do what?
Would you suggest that you should never question a president's actions with respect to an inferior officer ever?
Well, I think it raises, I think the constitutional hurdle that you have to cross over to get into that, which doesn't exist here, you try to put that into a perspective, and what would be the standard on when you do that?
Believe that there was corrupt intent, illegal intent.
What would be the illegality? If the president were, do you think a president could shut down an investigation if that president has decided to do it? Hasn't happened here, by the way. Despite all the protests to the contrary, the president hasn't done that. Do you think that a president has the constitutional authority to shut down an investigation? Because presidents have done it.
I know.
I'm not saying it's not complicated, but it's historical fact that it happened. But it's not happened here. So you know what?
Well,
the fact is, guess who's still there? Jeff Sessions is still the Attorney General, and Bob Mueller is still the
Jeff
Special
Sessions,
Counsel.
he could move on because he recused himself. I don't know why he isn't, frankly. He drags the guy all through the mud. He embarrasses him, and I believe you could argue embarrasses the White House at the same time because of the way he speaks about his Attorney General. But he keeps him there. I don't know why. But that's a separate.
That's not. You know what? You and I don't get to make that decision.
I know, but I get to report on it and analyze.
Sure,
that's all I'm doing.
Absolutely. Fair to analyze and report. But you know, well, and the president decided that Jeff Sessions, as of now, is the Attorney General. Hasn't moved him out.
But if Sessions were in charge of the Russia probe, which certainly involves the president, and then he removed him when it seemed that it was getting inconvenient, when it seemed that it was pressuring him, when he didn't like it. Now I think you have a different question, and that's why obstruction of justice comes in.
Except for one thing, one factual flaw. Where are we right now? Over a year into the investigation, is Bob Mueller still the special counsel?
Yes.
Has he been fired?
No.
Right.
But why is that the end of it? We're talking about Jim Comey.
Well, let's talk about this.
We're talking about Jim Comey and why he got rid of Jim Comey.
You know.
And why Mueller wants to talk to the president about that decision.
You don't know what Bob Mueller wants to talk about.
I believe that Bob Mueller wants to talk to the president about why he fired Jim Comey.
Do you
and
also
he believes
understand?
That one of the reasons he's pushing you for an interview is because he believes he can only get that understanding from the president himself.
Well, I mean, just think about what you said just then. I mean, and like I said, we're friends. Okay. You can only determine, in your view, what the status of the intent is by interviewing the president.
Yes.
So what prevents then every U.S. attorney from doing the same thing? You fire somebody, you don't like it, I think there's bad intent, so I'm going to interview. You think the president should be subject to
subpoena? It's not as simple a scenario.
But that's
you have an investigation that involves the president. He removes the guy. He says he removed him because he didn't like the probe, and you want to know why.
If Hillary Clinton would have fired James Comey, would that have been okay?
Would he have been in the middle of an investigation?
No.
And threatened her presidency?
Well, do you think she could not fire him?
Context matters, Counselor.
That's what I'm saying. If you think under the context of the election and the And listen, I was very critical. You know this, Chris. I was very critical about engaging and unengaging that took place during the campaign.
Right.
I thought that was.
I remember.
There's a reason. There's a policy that says don't do that.
He should have shut his mouth. I think that that's fair consensus.
Okay, so he did. So he's now terminated. But you know what? Here's where we are. Let's talk about where we are. Because you've asked the question. So I'm not going to preempt you asking the question, but I know the question. So where are we? So we've been doing this now for a little over a year. We have provided over 30 witnesses to the office. Unprecedented. Over 1.4 million pages of material. Unprecedented. We have not done what, and by the way, I'm not saying President Clinton didn't have the right to challenge the document productions that he did. He had the right to do it. We didn't do that here. That's not what my colleagues did. They provided the information. They provided the witnesses. So if you want to determine, and as you know, the president is very direct with what his opinions are and his positions. And you don't have to do a lot of investigating to determine that.
But it's different to speak to him directly.
Yeah,
you know.
But here's, well, look, Chris, here's the thing. I am representing with a team the President of the United States in his capacity individually. Then the White House has their own interests. And you got to be careful about precedents you're saying. But let me say this. We have had, and I think Bob Mueller would say this, a professional, ongoing dialogue with incredible transparency. Are we entitled in good faith to negotiate these various issues that you're about to raise
100%.
or you are raising? Of course, that's our job.
100%.
That's I'm not going to give you where it is in the negotiation. I'm not going to tell you what
It would be nice if you did, especially for your first
I
appearance
know
on
that
the show.
Yeah. Chris,
In the interest of transparency.
I know, but I'm not going to do that for anybody. It's not, that would be inappropriate for me to give that information. But I will tell you this: the discussion's ongoing. I believe that there'll be resolutions of this because that's the way these processes tend to work, and we'll see what happens. And I'm convinced, at the end of the day, that if we stick to the Constitution on all of these issues, it tends to work out best for the country, and that's really important here. I think we all agree with that.
Rudy Giuliani suggested to me that I will not be asking you guys these questions about whether or not there'll be an interview after Thanksgiving. Do you still hold to that as a
Let me tell you one thing I have not done. Okay, I have not given a date. Despite a couple people, I have never given a date. I don't give dates. That is not the business I'm in. I'm advising the client. Now, Rudy,
it's a period. It's not an exact date. It's a period.
Yeah, well, look, Rudy has a lot more experience than I do in these kind of matters on this. I'm the constitutional lawyer here. So I look at the Article 2 issues, the issues you and I have had a great discussion about. Rudy's job is different. He is the lead counsel on this, and he's evaluating those with our team. And that's the process we go through. And we all have a collaborative effort, as does the special counsel's office. And Rudy may be right. Maybe it is resolved by Thanksgiving. I think for the good of the country, it should be resolved really soon.
Well, if you want it wrapped up, you have to wrap this part up.
Well, you know what, though, Chris? This is, and I think you know this. Let's be blunt about this. This has not exactly been a regular investigation. I mean, the things that have transpired over the last year are pretty unprecedented. And I'm not going to go through starting with the Christopher Steele dossier and the text messages and all of this. But you have to look at all in the context. But despite that, we still have maintained, and the president has maintained, transparency and a commitment to giving documents unprecedented in history. You acknowledge that it's true. I mean, that was the position that my colleagues took about giving information and putting that information forward to the special counsel's office, and they've done that.
But the key offer is him, and we'll see where that goes. We got deeper into Kavanaugh and this than I expected to, so let me get to one more thing. I don't want to take up too much of your time.
Yeah.
People will not probably know this, but you represent Pastor Brunson, all right? Who's Andrew Brunson? He is the pastor who's being held by Turkey. The United States government believes it's for wrong reason. We thought that there was going to be a breakthrough, that he was going to be released, that Turkey would at a minimum be pressured to make a show of what espionage or what grand claim they have against him, and then it went quiet. Why?
Yeah. Well, a couple things have happened. I really appreciate you bringing this up. First of all, the charge actually against Pastor Brunson in the criminal indictment in Turkey is Christianization.
Right.
So what they believe is espionage is him, a pastor of a church of about 50 people in Izmir, Turkey. Look, I believe it's a political moment. The president and the Secretary of State, but the president's been very aggressive seeking his release. I do have some good news, and that he's returned to house arrest. Now, that's a lot better than being in a jail in Turkey, as you can imagine. But there's still an ongoing trial, and I will tell you this, the administration, the president in particular, vice president, secretary of state, are working diligently to secure his release, and the release means getting him home. But at least he is out of that jail, and that's the first step. But look, I think the politics of this are way beyond what we can deal with, and the fact is, I really appreciate you raising it, because meanwhile, this pastor has missed his daughter getting married,
Right.
graduations from school, and I can't even imagine the pressure. And I have to speak to him when he got, the first time I ever spoke to him, Chris, was when he was allowed to go home. To his, he's under house arrest, so he can't leave.
Right.
But it was the first time I ever spoke to Andrew Bunch. We took the case once he was incarcerated. We thought it was going to be a short term, and they would, basically extradite him out or just throw him out of the country, and they didn't.
Well, the trials
and
there are so political that the concern is that
Yeah.
if they allow the trial to end and you get a sentence, it then becomes much more entrenched.